Justice Tshiqi.
Good morning, It's been a long day, Chief
It
Justice.
has been. It has been.
Good
Yes.
evening, Chief Justice.
We apologize to you that we should have completed this this interview almost 4 hours ago.
It's okay,
So
Chief
we
Justice.
apologize that we kept you waiting this long.
It's okay.
Yes. You were an attorney for many years before you went to the High Court.
Yes, Chief Justice.
And you've been you were a judge of the High Court for about, is it 5 or 4 years before you went to the Supreme Court of Appeal?
4 years, Chief Justice. I was appointed in 2005,
Yes,
and I went to the Supreme Court of Appeal in 2009.
yes. And you have been at the Supreme Court of Appeal for almost 10 years now.
Yes, Chief Justice. I'm part of the furniture there.
So you spent more time at the SCA than you did at the High Court.
Yes, Chief Justice.
And of course, you've also acted at the Constitutional Court.
Yes.
Tell us how this whole experience, the totality of this experience as an attorney, acting judge of the High Court, permanent judge of the High Court, judge of the SCA, acting judge of the Constitutional Court, have prepared you for permanent appointment to the Constitutional Court. Just in your own words, just tell us how all this have helped you to be as ready as you believe you are for the Constitutional Court.
Part of the work that I did, Chief Justice, as an attorney, was to preside in disciplinary hearings. And I was also an arbitrator. And in fact, this issue was mentioned during my first interview for the High Court. So at that stage as well, I had acquired a few judicial skills in terms of adjudicating and writing. But the High Court exposed me to more, because as a CCMA commissioner and an arbitrator, it was basically writing on mainly issues around employment law. But when I got to the High Court, I then had to adjudicate broader matters. And Johannesburg is one of the busiest courts in the country. So I did a lot of matters and a variety for that matter. And I remember, Chief Justice, how overwhelmed I was when I first went to the motion court, full of counsel, some standing on their feet. But I managed that motion court role, as difficult as it was. And I also learned that even though one does not have time, one would have to find time to write judgments as quickly as possible and as clearly as possible. The other exposure that I got was when I had to now sit on appeals. Remember, as a sole practitioner, I was sort of responsible in running my own practice. And I realized there that I had to work with other colleagues and work well with other colleagues. And that kind of exposure in a busy court in the country sort of exposed me to a diversity of other areas of the law. Yes, in my own practice, I was doing a bit of commercial law and employment law and criminal law, but then I was not in a position to choose. I had to do whatever was put on my platter. So my stint at the High Court prepared me. And in fact, I was told when I got the time to ask President Mpati why I was called to go and act there, and he said it was because of the judgments that I had written. And certain colleagues went to him and actually said that he must invite me to go and act in the Supreme Court of Appeal. This is my time to talk about myself and tell the JSC about myself. I never went back to the High Court. I made myself available and I was appointed to the Supreme Court of Appeal. Different environment, Chief Justice. Whilst in the High Court, I would sit with only 3 judges on appeal. In the Supreme Court of Appeal, I then sat with 5 judges most of the time. Yes, there are appeals where one sits with only 3 judges, but those are only few of the matters. And also, the way the Supreme Court of Appeal works, it's a very thorough process, Chief Justice, in the sense that whilst at the High Court, in certain instances, I would be given a file and only get a short opportunity to prepare. In the Supreme Court of Appeal, I was given time to read the pleadings and read them thoroughly and prepare. But what I found daunting at first was sitting in court and you have prepared as a judge and you trust yourself, you've been in the High Court, and then you find from the questions that are being asked by the other colleagues that in fact there are other issues that you should have paid attention to. And I found that enriching because what it did for me was to show me that in fact, in each and every file, each and every sentence in pleadings is important and crucial. And I benefited quite a lot from that. And then there's the judgment writing. The judgment writing where you think that this is the best you can do, you circulate to colleagues, and when colleagues make suggestions, you realize that in fact, I like this paragraph. It is said so well that I should adopt it. And so I've gone through this whole process of Chief Justice with colleagues actually nurturing me. And one of the things I was told as well, specifically by President Mpati then, was that once you have prepared a file, approach colleagues, because colleagues will show you another way of looking at a matter. And I also learned at the Supreme Court of Appeal, Chief Justice, that it helps to expose oneself's ignorance. Because if you sit in your small corner, you do not learn. Whereas if you go to other colleagues, they actually broaden and enrich your knowledge about a matter, about issues in a matter, and actually about your judgment as well. As we speak now, Chief Justice, I'm the 6th senior judge in the Supreme Court of Appeal. I preside in matters. It has been enriching for me, sometimes hard, because one thing about the judges of that court is that they want to ensure that whatever goes out in their name, they're happy with it. And as a presider, The challenges are this. Yes, you prepare at home, but when you go to court, you have to think about the views of your other colleagues on the bench. And when counsel debate issues in court, you have to try and make sure that through questioning, everybody is brought back to the real issues. I've always admired my colleagues who were able to do that, and I think I learned quite a lot from them. And I've had feedback from my colleagues who have sat with me that, in fact, I managed that skill well. Judgment writing, Chief Justice, I've had positive feedback that my judgment writing has improved. I am told I write well. I try, Chief Justice, to write as short and as concise as I can. The feedback that I've received is that, in fact, I write well. Even this term, I recall that my secretary came to me and said that one of the judges I was sitting with was looking for me. I was number 2 in that bench. And when I got to his office, he said, no, I wanted to compliment you on the judgment that you've written. It's well written. I've got no suggestions. So those are the things that build one's confidence, Chief Justice. And then let me talk about the experience at the Constitutional Court. Whilst at the SCA, I was sitting with 4 other judges. At the Constitutional Court, I was now sitting with more judges. That was enriching as well, Chief Justice. Specifically because there, after you've come out of court, there's a flurry of emails about several issues that arise from that matter. I found it challenging, but also benefiting to the judgment, that in fact, by the time you ultimately sit down and write your judgment, you've got a lot of information to work with. It also helps that there are competent researchers there who actually research these issues and you can call on them. So added to my experience as an attorney for so long, because I was admitted in 1991, so added to that experience that I had got then, I think that I'm an all-rounder. I've been to the Competition Appeal Court, I've been to the Labor Court, and I've dealt with all sorts of matters. And as you know, in the Supreme Court of Appeal, we get all sorts of matters from different fields of the law.
Thank you, Justice Tshiqi. Colleagues? Commissioner Msomi?
Thank you so much, CJ. Good evening, Judge.
Good evening, sir.
Judge, may I refer you to a book that is titled Constitutional Court 2 Vacancies, Book 2 of 2. And
Here.
yes. And it's a submission by the GCB in respect of your candidature. And I think it's page 3, paragraphs 4.4 and paragraphs 4.6.2.
Book 2.
Yes, Book 2.
And should I check in the section that deals with my name?
Yes, please, Judge.
I want to find it, but I think I suspect what you want to refer to.
Yes.
Just that I can't find it now.
Okay, let me just summarize it for you. My colleagues on my right, GCB, they make an analysis of the judgments that you have set in, and they say you have been a member in 216 cases. You have concurred in 175 judgments, and they say that is 81%. We have written 41 judgments, and that is calculated at 18%. And they say of the 41 judgments you wrote, 34 were in the Supreme Court of Appeal, and of the full sample of
Oh, thank
judgments
you.
written,
Thanks.
11 were civil matters and 18 were in criminal matters. So having done that analysis, they then conclude in paragraphs 4.6, 4.2, and 4.6, 4.3. Of importance, I think, for the benefit of this commission is that, and I'm going to read it out to you, while this exposure was inevitably beneficial, the relatively small number of judgments written by the candidate does not permit any empirical appraisal to be made of the range of her legal expertise. And in addition, there is no clear evidence of development of a field or fields of expertise in a particular area of civil law.
Yes.
That is the concern that they seem to be raising. But overall, I think you get a positive response from them.
Yes.
Do you want to comment in respect of that comment?
Yes. Firstly, unless I am reading this wrongly, I wonder if the judgments I wrote in the High Court were factored in this. I wrote lots of judgments. When I was responding to the Chief Justice, I said that, and I think it's common knowledge in this room, that in that court, it's one of the busy courts. So the judgments that are reflected here do not reflect a total number of the judgments that I've written, number one. Number two, I got concerned when I looked at the judgments that were attached to this comment. Because if you look at the annexure, it says list of judgments considered. I don't know whether they were considered broadly or whether these are the only judgments that the GCB could find. I've written much more judgments than this. Most of those judgments are attached to my application. And in my application, I attached judgments I could find online, only the judgments I wrote in the Supreme Court of Appeal and the Constitutional Court. So it's not accurate.
So, Judge, the long and short of it is that this statement is not an accurate reflection of who you are.
No.
You are ready to serve as a constitutional court judge, given
Yes.
your experience here. Judge, let's get to your judicial philosophy. Are you a judicial activist, or are you a conservative? Are you conservative in your approach when adjudicating matters?
I would not want to be pigeonholed, Commissioner. What I consider when I'm adjudicating is the Constitution. I look at the Bill of Rights. I am guided by human dignity, accountability, transparency, and equality. So all those issues that are in the Constitution, those are my guiding principles. Because at the end of the day, Commissioner, I have to adjudicate without fear, favor, and prejudice. And what guides me is the Constitution. I try to stay away from taking a stance that would be popular, but not guided by the law or the Constitution. So, fairness is always foremost in my mind.
Perhaps let me ask the question differently, because I appreciate the danger of pigeonholing you. The late Chief Justice Pius Langa, he wrote a piece on what he called transformative constitutionalism. And he listed a number of challenges that face that philosophy of transformative constitutionalism. And one of the issues that he raises sharply in that article is what he calls the formalistic approach of the legal culture of South Africa, vis-a-vis what he calls substantive reasoning in our adjudication. Perhaps within that broad philosophy, where would you belong? Are you formalistic, or have you crossed the Rubicon, as it were, to adjudicative, or rather substantive adjudication?
You can't, in a country as diverse as South Africa, you can't be formalistic. That is why I said the most important thing is that even if you believe that you want to be active, in a sense, you have to do so within the boundaries of the law. So, and I know this because, I mean, I've listened to interviews, and this whole concept about activism, I wish we could find a different word for it, because you don't want to be said to be activist in a sense of forgetting that at the end of the day, you've got the Constitution, you've got the law.
Judge, I'm not sure if I'm getting the answer that I'm looking for. Are you able to point me to a decision that you have penned where you have developed common law in line with the new constitutional ethos?
Yes.
That you look back and you say, wow, that was it. Thank you.
I didn't pen it, but in Pakshawo, we developed the common law. In fact, if it was before me, I would refer you to it, because there we had to decide what are the bonimores of the society at the present moment, and we developed the common law.
Thanks, Tshiqi. No further questions.
Thank you so much, Commissioner Msomi. Commissioner Norman?
Thank you, Chief Justice. Good evening, Justice Tshiqi.
Good evening, Commissioner Norman.
Yes, thank you. Maybe just following up immediately after the question on the development of the common law, have you ever penned or having been a part of a bench where you developed customary law?
Nothing comes to my mind now, Commissioner.
Yes, thank you.
Norman.
And can I just...
If I think about it, I will.
During
I
the
will.
course of the interview?
During the course of the interview. Nothing comes to my mind right now.
Yes. I understand when a judge writes a judgment, a judge must at least reflect the judge's awareness of social problems within society. But how far can you go as a judge in really dealing with those difficulties that you observe happening socially, not what appears before you on the papers? How much of it can you take into your judgment?
It really depends on the kind of matter you're dealing with. Let me talk to criminal matters. Criminal matters, it's easy to take into account certain things that are happening around you by making use of experts like your social workers during the pre-sentencing report and so on. Because these are the people who are trained in order to go and source that information, in order to inform your decision. Civil matters, as you may know, Commissioner Norman, we tend to be constrained by what is in the pleadings. And you find that that kind of restriction sort of restricts you to determine the matter based on what is before you. Yes, you can mention it in the judgment for what it's worth, but it cannot inform your decision. Your order will not be based on it. This is what I'm trying to say. Yes, you can mention it, but you will realize, if you think about it, in most criminal matters, you hear judges lamenting certain practices. Sometimes the judges would then ask for information to be sourced so that they can take it into account. So as much as we want to be, to take into account everything, sometimes it just constrains us. Yes, there's provision in all the courts to ask for supplementary heads.
Yes.
But you can't ask for supplementary heads that are irrelevant to the nature of the matter that you are dealing with.
Yes, thank you. Justice, am I correct that your last acting stint at the Constitutional Court was in 2015?
Yes.
And during that time, and I think you availed yourself thereafter for a position at the Con Court, am I right?
Yes.
During that time, can you recall what the comments of the GCB were in relation to your application?
I can't recall that there were any negative comments.
Yes.
From the GCB.
Yes, I've just called for that interview's comments of the GCB so that we can at least balance it up and see whether they were still, even then, they formed the view about your judgments that they formed now, so that we can compare and see whether they've been consistent in their approach. But with the leave of the Chief Justice, I'm going to ask that as soon as that record comes to hand, that I be allowed to put that question to you.
Okay.
Yes, thank you. Thank you, Chief Justice.
Thanks, Commissioner Norman.
Thank you so much, Commissioner. Commissioner Mpofu.
Thank you. Good evening, Justice Tshiqi.
Good evening, Mr. Mpofu.
Thank you. I'm just going to ask you about one subject that is of some concern, and want to hear your comment. And that is a subject that I recently had occasion to address at the National NADEL conference. And it is about the fact that the Constitutional Court does not normally give reasons in matters in rejecting applications for leave to appeal. As you might know, what happens is that you get a one-liner, really. It either says the appeal has no prospects of success, or it will say it is not in the interest of justice to hear the matter, or if you're lucky, it says it's not in the interest of justice to hear the matter at this stage. That's it. No reasons given. And it's, I can tell you that it leaves many practitioners with a lump in their throat and inability to explain to the clients what actually happened. In one example, a case that I was involved in, I think they were done something like 50,000 pages because, you have to do 25 copies and all that, to probably cost the client R500,000, just the whole thing, yeah, excluding paying the counsel. And then you just get this one-liner. Now, there's a view. One of the reasons that is given is workload, which is understandable. So let's just put that aside and say, assume that that can be addressed either by the court not necessarily sitting on bank or by increasing the number of judges or whatever. Would you agree that this practice should be, that we should all use our collective minds to try and stop it? Because it's patently unfair to litigants, and that there's no reason in principle really why you should be entitled to reasons from an administrative body, but not from a judicial body, because the consequences the human consequences of a judicial decision might be much more devastating than, as I always say, not getting a dog license from the licensing body. What can be done to address this? And firstly, do you agree that it's a serious injustice, patently? And if you do, what can be done to address it?
I'm going to take a bit long to answer this question, Commissioner Mbofu,
Thank you.
because some of the reasons for that you have identified. You've touched on
Workload.
workload. You've touched on resources. But I want to answer it this fashion. And I'm going to start with the Constitutional Court, and then I'm going to go to the SCA because we have a similar process.
Yes.
What happens when we get these applications is that it's not a matter of us, just paying cursory glance at the application for leave to appeal. What happens is that the judges look at the application of appeal, they consider it, and once it has been considered in the Constitutional Court, memos are exchanged between those two judges who are considering the application for leave to appeal. And then a final memo is written by them. So a lot of work goes into the application for leave to appeal. And then it is sent to conference to all the judges of that court. And a decision is only made thereafter. So it's inescapable to then come back to what you have identified, to say that the reason why parties would not get a judgment is because of workload and resources. Because, as you know, or may not know, before a judgment in an appeal, not an application for appeal, goes out, it goes through several drafts. And you can imagine, with the flurry of the applications for leave to appeal that we receive, if we were to give candidates a comprehensive judgment on each one of them, I think that then the judges of that court would have to be doubled, if not tripled. But there are instances, Commissioner Mbofu, where the Chief Justice and the judges would decide that, in fact, this particular application cannot be or should not be disposed without giving reasons. And in those instances, a short draft is done in order to do exactly what you're asking for. So I'm not saying it's fair. You have to realize that we try and be expeditious and be fair within the limited resources that we have. So it's not a perfect way of dealing with the applications, and your point is taken, and that point is fair, but I thought that let me unpack for you so that you understand the reasons for it. But also, to get comfort from the fact that the process leading up to that letter, that is just a 2-page letter, is actually a comprehensive process itself. And then I want to take you to the Supreme Court of Appeal, because we've got a system like that as well. Same process, we debate this matter. At the end of the day, we send a one-page or 2-page letter. But the process is comprehensive, and we apply our minds to it. Is it a perfect way of dealing with it, Commissioner Mpofu? No, it's not.
Thank you. No, so just a quick follow-up. No, firstly, I accept, as I say, the workload reason, but also I'm not asking for comprehensive reasons. I accept that it might not be a model of, a thesis or a judgment that flows with flowery language. But so I don't care whether it's 10 pages, 5 pages, 1 page for that matter. But the point is there no fundamental entitlement similar to the one that is highlighted in Section 33(2) of the Constitution, which says everyone has rights to have, whose rights have been adversely affected by administrative action, has the right to be given written reasons. A right, it's a constitutional right. Now, my argument is that the fact that one is an administrative decision and another one is a judicial decision should make no difference at all in principle to the entitlement of somebody to be told, to be given their constitutional entitlement to be given reasons for a decision that adversely affects them. And so the answer might be a shorter judgment or whatever, or doubling the judges, but surely the answer cannot be a blanket ban on that entitlement to reasons. And I'm not comforted by knowing that it's a comprehensive process and so on if, firstly, I don't know that and I cannot explain it to a client who has spent R1 million trying to appeal to the highest court only to receive 5 words. It's what does it say? No prospects of success.
I hear you, Commissioner Mpofu. This is why I first agreed with you that it's not a perfect system, but I thought that I must explain to you the reason for the imperfection.
Thank you, Chief Justice.
Thank you so much, Advocate Mpofu. Commissioner Singh?
Thank you very much, Chief Justice, and good evening, Justice Tshiqi.
Thank you.
You know, of the 400 members in the National Parliament, there are probably 3 or 4 of us that wear these age badges religiously. And the reason we do that, the 3 or 4 of us, is because we appreciate that HIV and AIDS is still a major, major problem in our country. Now, when you look at the statistics, in 2017, it's reported that there were 322,000 cases of TB, and of those 322,000 cases, 60% were HIV positive, about 200,000 of them. Now, the reason I raise this is not because I want everybody to wear these badges, but because I see in the documents that you've submitted that there is a glowing recommendation from the Magistrates Court's Judiciary Republic of South Africa, signed by the Chief Magistrate of Kimberley, Mr. O.M. Kriling, where he compliments you for delivering a keynote address. And the topic was Why judicial dialogue on HIV and the law in South Africa? Now, what I'd like to know, ma'am, is in this letter he says she reminded judicial officers throughout about our constitutional duties in this regard. And I would really like to know briefly, what are the constitutional duties in this regard of HIV and AIDS?
Commissioner Singh, you've already said that in fact, let me rephrase that and say that if we look at the Bill of Rights, the Bill of Rights in section 10 talks to human dignity. 11, the right to life. And then it talks to housing, and I'll explain why housing also touches on TB and HIV. Healthcare, food, water, and social security. All these rights are impacted by the scourge of HIV and TB. Why? HIV and TB are now referred to as the twins because they tend to affect the more vulnerable members of our community. That is the poor, the homeless, the landless, and the more vulnerable members of the community. So you cannot talk about HIV and TB without talking about the constitutional rights of a community. So that is the connection. Why was it necessary for this to be introduced to magistrates? Magistrates are at the coalface of all of these human rights violations. When people living with HIV are victimized in society, or when they are subject to attack because it is perceived that they are not protected. Let me put it that way. It is the magistrates themselves who have to deal with those kind of cases. So magistrates, it's important, and I thought it was important when I attended the courses in the Regional Judges Forum, that this information about the understanding of the complexities around these issues must be filtered through to magistrates. Let me clarify the connection. It is a known fact that it is the key populations that are usually infected with TB and HIV. What do I mean by key populations? It is the gays, lesbians, and all the populations in the LGBT groups. Those are the ones who find that they are affected by HIV and TB. So because of the human rights violations that they suffer, because they are targeted, it was felt that magistrates, because they deal with these assault cases and issues around their victimization, they should be trained on these issues.
So just as a follow-up, Chief Justice, so do you feel, Justice Tshiqi, from your experience, that there is some sort of discrimination against people who have HIV and AIDS?
And
For
TB.
you to have raised this matter so sharply in a conference? And are there examples of this kind of unfair discrimination that you can tell us about?
Yes. there are examples of those kind of cases. In fact, in one of the conferences, we paid closer attention to cases that were heard in the magistrates' court that dealt with these kind of issues. I hope I carried them with me. I didn't want to carry a lot. But during the debate, it transpired that there were several of these cases that come to the magistrates' court, and that the magistrates did not really understand how to deal with this kind of matters. And it was then felt that, when I say felt, it was a discussion that I had with the head of the South African Judicial Education Institute, that the magistrates ought to then be exposed to these kind of matters. Let me mention, Commissioner Singh, as well, that in these conferences that we hold, we are able, through the UN, to invite victims of these kind of atrocities. They actually come there in these conferences and tell their real life stories about the injustices that they are perpetrated to them.
I'll leave it at that, Chief Justice. Thank you.
Very much, Commissioner Singh. Commissioner Schmidt?
Thank you, Chief Justice. Judge, there was quite a few times a reference made during the course of the day to the top 6. You started your interview by saying, I think you said you're number 6 on the seniority.
Yes.
And you also referred to being number 2 in a certain panel. I think I didn't quite follow that. But for what, in your view, is the importance of the hierarchy of seniority? What's the importance thereof within the functioning of the Supreme Court of Appeal?
I mentioned it, Commissioner Smith, because it reflects how long you have been at the Supreme Court of Appeal. Because what happens is that the most junior person is at the last number, usually number 24. So as you rise within the ranks, you rise in number as well. That system is used really to allocate matters, in the sense that the heads of that court want to sort of pair the more experienced members with the non-experienced members. I know that that system of ranking has been notorious because of certain personalities and certain injustices that were perpetrated in the past. So the whole notion of a top 6 and so on, and we are quite aware of that. And I mentioned it deliberately in this room because I know that this room has unpacked that issue. And I can tell you, if you invite me, what this present president has done in order to deal with those weaknesses. But let me go back to your question. So what then happens is that as you rise, meaning as you stay at the Supreme Court of Appeal longer, you then rise, you then given more responsibilities in making sure that, one, the more junior judges are guided. Because President Maya always says that it doesn't help for you to be senior if you are not going to guide more the acting judges and the junior judges. So you're given that responsibility of guiding the junior judges, and they are told when they arrive that they have to seek guidance from the more senior judges. So that's the significance of that. So for me, it's an attribute, because whereas I started at number 24, I'm now at number 6, which then for me reflects the kind of exposure that I have and the wealth of experience that I have in that matter.
Does that also reflect the weight of your views amongst each other?
No, not necessarily. In fact, quite the contrary. Let me explain it this way. Some judges stay longer in the High Court. Some judges stay longer in the bar before they come to the bench. So the fact that you are at number 6, it doesn't necessarily mean that you should not listen to a judge who's actually who stayed longer in the High Court. That judge may well have more experience than you do, or in the topic, that judge may actually have more speciality or exposure in that kind of a topic. So it should not be used like that at all. And we always debate this when we have meetings, that irrespective of the fact that you are given that kind of seniority, you should learn to listen to the other colleagues. And in reality, most of the time, this is what happens.
Thank you so much. Commissioner Modise?
Thank you, CJ. Just wanted to follow up on this. On Commissioner Smith's question, Mayor Judge, you say the longer you are, the higher you rise and the more work you get.
The
Am I
more
cor-
responsibility you get.
Okay. The more responsibility you get. So you get your responsibility because you have been there longer.
Yes.
The work, I don't understand the Ngupovu. Don't understand how then, in your setup in the judiciary, you get allocated the work because you have been around longer. And you don't get allocated the work because you are the best person in a particular area of work. Do I understand you correctly?
Let me explain, Commissioner Modise. When I talk about responsibility, I talk responsibility of making sure that earlier I had said that when you are presiding, you have the responsibility of directing the debate in court. The way we work is that in court, counsel would debate a matter. And then when we come out of court, we debate the matter. And it is the responsibility of the senior judge to sort of take the lead in terms of telling the other judges what their view is in the matter. And then the other judges follow. It's a huge responsibility in the sense that you then get to say what your views are on that matter. And nobody's bound by your views, by the way. But the responsibility I'm talking about also entails the fact that if the scribe, if the judge who is scribing has got difficulties, our arrangement is that that judge should come to any judge, but specifically to the presider, to come and seek guidance. When you realize that, in fact, a judgment is not coming out, it is the responsibility of the senior judge to keep on going to the scribe to ask how far and offering to assist. So it's not responsibility in terms of the quantity of the work. It's basically that responsibility of making sure that you manage that particular matter and you give guidance and support to the scribe. It's that kind of responsibility that I'm talking about.
So the longer you stay, it's like a chain, a conveyor belt. As you come in, you are the last one and you go through the conveyor belt. And as you go through the conveyor belt, the more responsibility or the guidance is required for you for the newcomers. Do
Yes.
I get you right?
Yes.
So it has nothing to do with the quality of work that a newcomer, number 24, might bring into the court. It only has to do, the seniority is used, it is about tenure. The longer you are, the more senior you are, you just go through as vacancies come and ni pushana ni apambil. That is exactly how I understand you to be saying.
Well, let me paint what used to happen in the past, and I hope I'll be able to answer. In the past, there wasn't really supervision on the quality of the cases that were given. And judges have come to this commission and actually complained that you'd find that as a junior judge, you'd get non-matters. Usually, you know, your sentence and on and so on and so on. And the first person who exposed this in this commission was President Maya. And after her interview, we had a relationship building exercise to actually deal with exactly those issues like the fair allocation of work and so on and so on. What happens now is that even though as a senior, you have that responsibility to give guidance and so on and so on. When the roll comes out, she checks whether the junior judges have got quality cases.
Just to round off, so when you are a senior, you have had a chance to get, I suppose, quality cases, to quote you? And that prepares you to, and it prepares you, but it also earns you the label of being the senior judge.
When you are a senior, when you are a senior, look, in the past, that is why I said, if we look to the past, this is what used to happen. Right now, when you are a junior judge, you are able to get a quality case, right? But you work under the guidance of a senior judge.
And can a junior judge descend from a senior judge who is mentoring or, as you say, guiding?
Yes, it happens all the time.
And there would be no problem into the future relationship amongst these colleagues who are all judges on paper, senior and junior?
If I said there would be no problem, I'd be lying, but there should not be any problem.
Judge, in this senior-junior relationship, have you ever seen any unfair practice or perceptions by those who are junior to yourselves, perceptions of them being treated unfairly?
Yes, Commissioner Mudisa.
What have you done about it?
On the occasions that I've seen some judges complaining about injustices and unfair practices, well, let me say in the past and now, because I'm in the tricky position that when I talk about the SCA, I have to talk about the past and then I have to talk about the present. In the past, I would simply give those judges support and try and help them, the ones who felt aggrieved, and actually help them, and helping a person meaning it means being there for the person and actually assisting and even inviting that judge to come and allow you to work with them in terms of helping them to make sure that you read and proofread the judgment before it goes out and so on and so on. But in the present environment, what happens is that during the first week, acting judges are told that we are all equal as judges, and that when a person needs assistance from any of the senior judges, they are free to help. And personally, myself and other judges, we go to the offices of the new judges and try and see how we can help them.
Judge Tshiqi, do you think that the system, the processes that you have to discipline judges is adequate?
Which process, Commissioner, the JCC?
I suspect every judge would know their process.
No, I want
Is that the only one you have, the JCC?
the process of the Judicial Conduct Tribunal. That's the only process. And no, it's because we were talking about my court and now we're talking about
Yes,
that
I'm
process,
just
yes.
finishing
So
off what I wanted to
yeah.
put to you.
Yes, yes. I have no reason to think that it's not adequate, Commissioner Mutise, because my understanding of it is that whoever is heading that tribunal has got a right, if they believe that the conduct of the judge is impeachable, to refer it forward so that that judge can be impeached. So I think it's adequate.
But it would seem to me that the conduct of the judge who, the woman in the street sees as really impeachable is so, the process is so complicated that judges actually don't get impeached when they should be impeached. And therefore we sit with people who should be impeccable, people who preside and decide about the lives of ordinary people there who, and I'm speaking here representing the people around this table, who actually have questions about the integrity there, but these people, because of the complexity of the system, watch and see. So isn't it time that, Nina, senior judges, you actually even guide yourselves into this process of dealing with these? Because I think that sometimes we get very frustrated. You may or may not respond to that, and I thank you, CJ.
Well, you're talking about the Supreme Court of Appeal, aren't you?
Yes.
You're not talking about the whole judiciary.
Yes, Chief Justice.
What is to be done under the following circumstances? For instance, I was approached by 2 Supreme Court of Appeal judges. One was acting, the other was a new permanent judge, raising some of these concerns. But one of them said, I don't want it to be known that I complained. How do you take it to the JCC where the complainant must give an explanation boldly and even be questioned if necessary? Is it capable of being resolved if a judge who's supposed to do things without fear, favor, or prejudice is refusing to expose something wrong? In circumstances where those that are doing something wrong to them can't fire them, they don't have any power to harm them at all. What can be done?
Chief Justice, if a judge comes to complain to you, then they should ask you to do something about it and disclose the identity of the judge they've come to complain about.
They are refusing.
Otherwise, what's the point?
Exactly. One of them said, and there's the permanent one, he said, I'm prepared to I'm prepared that Judge so-and-so and Judge so-and-so be approached, but not so-and-so. They've done, that so-and-so has done a terrible thing, but please, that one, don't mention him or her. How do you deal with that?
I wonder what would cause that, because even if I came to you, Chief Justice, and said, Judge, so-and-so, and I'll mention my president, and she knows she's done nothing to me, but if I came to you and said, Judge Maya has done this and that and that and that, what can she ever
Yes.
do to me?
Sure. And by the way, unless the head of the court is himself or herself unable to handle a complaint and refer it to me, I would be undermining the authority of that head of court if I just jump over him or her to do what they are supposed to do. Is it not so?
Yes, Chief Justice.
Yes. Otherwise, it's an easy matter for me.
Yes.
Okay.
And Chief Justice, all these issues, what I like about her approach is that if you go and complain to Judge Maya calls both of you
Yes.
to her office. She doesn't call just one person.
Yes.
And she doesn't take it to the tea room and talk to people about things that they don't know.
Yes.
She's a head-on person.
And she's the first to expose what is actually happening there.
Yes.
Never before did we hear until
Yes.
President Maya was interviewed here. Otherwise, we may never have had an official record of what's happening. You're excused, Justice Tshiqi. Thank you very much for being here until now.
Thank you, Chief Justice. Thank you, Commissioners.
Thank you very much.